We're live. Sorry.
It's okay. Okay, we're good? Yeah. Okay, all right, good morning. This is Senate Natural Resources and Energy, and this is Thursday, January 22nd. And we are starting off the morning with S202, portable / plug-in solar. And Ellen Tchaikovsky, welcome for the new draft.
Yes.
Huzzah.
Ellen Tchaikovsky, Office of Legislative Counsel. So today you're going to be looking at draft 2.1 of the committee amendment to S202. There was no draft 1.1. You didn't miss anything. In the last couple of days, Senator Watson had reached out with changes based on the testimony you heard, and so I had multiple changes before I even came back to see you. So that's why it's 2.1.
My fault.
You're not missing anything. This document, the changes are highlighted in yellow, and I will point them out to you, because some language has just been deleted entirely. And then there are two brand new sections at the end. So section 1 is the definition of portable solar energy generation device. So I also spent time thinking about some of the comments that you received, and in A, the version that's introduced had the maximum power outage or output for these systems. I have struck it from here and moved it to the regulatory section in section 2, and I think this makes it more clear, because you're going to look at aggregate or sort of cumulative wattage as opposed to each individual device having a specific wattage. And I think that makes the second section flow a lot more better. So the definition is, as you're proposing in section 1, is a movable photovoltaic generation device that is designed to be connected to a building's electrical system via electrical cord plug into a receptacle. That hasn't changed. Includes a feature that prevents the system from energizing the building's electric system during a power outage. That hasn't changed. But what was struck from B was the language that said it's intended to primarily offset the customer's electricity consumption. So that has been struck from this definition. And then subsection C has been updated. The new language is in yellow, based on the information from UL Solutions. So it's a generation device that complies with UL 3700 for plug-in photovoltaic systems by UL Solutions, or an equivalent certification by an equivalent nationally recognized testing laboratory for use in the United States. So you are specifically here referencing their most recent lists by specifically referencing 3700. I don't think you necessarily need to reference the number, but if that makes people feel more comfortable, you can.
So just as a note on that, so I'm hoping to get a letter from UL Solutions. We'll see if that comes through, but at least in the conversation that I had with them, they had at least verbally, and we recommended that we reference the specific standard.
And they use the language plug-in photovoltaic system, and so I didn't know if you wanted to change your defined term, or instead I just included it as a reference to that.
I think this is fine unless others have thoughts on, because one possibility is that we change it everywhere to just that term, but I think if this is in the definition of it, it's
Okay. And then still on page 1, subsection D has not changed, and so this device is connected to a building that is connected to the electric grid. To the electric grid. Okay. So on page 2, section 2. So the new language is in yellow, and I think I've added some things to make it slightly more clear. So on page 2, portable solar energy generation devices. A customer may install one or more portable solar energy generation device per meter if The devices have a maximum combined capacity of not more than 1,200 watts. So this is a change from the draft as introduced. This is not about how much is being exported to the grid. This is just the capacity of the device itself. One or more in aggregate, up to 1,200 watts per meter.
Yes.
Do you think, it may be more clear, or at least for me, to say per electric meter? Because when I first read it, I thought you meant meter, like the measurement meter, even though I know in the United States, basically, we don't use them.
Okay.
But that's what my brain thought, and I was like, wait, are they supposed to measure like that? Okay.
Okay.
I don't know.
The second sentence in subsection A is portable solar energy generation devices shall only be connected to systems using smart meters. Smart electric meters.
Maybe that doesn't matter so much there, because I don't know, what is a smart meter for when it comes to measure, you know?
Yes, okay. Maybe not the electric, right?
Now that I'm reading this, I'm wondering if that is, I guess it shouldn't be confusing, but like these devices don't plug directly into the meter.
Yes.
Do you know what I mean? Like,
Well, and that's why I phrased it connected to systems using.
oh, systems using, okay.
And what was the, I remember I did write that down, but what was the reason for that? It's gonna have a cost.
Well, so that was a request of one of the distribution utilities, that came after, but it's related to the comment about how, remember how like not all smart meters are the same, and so some of them, by adding some generation to it, it will just look like the usage is going up.
Oh,
And then I guess that was some kind of dumb meter, but we can get more testimony.
yeah, I'm not, because I think that was still, that's still how it would look on the smart meter. It would just look like the meter is slower.
Yeah, but I think what, if I understand it correctly, you're reminding the testimony was you'd actually get charged more for the troubles.
Right, like it wouldn't look like a reduction, it would look like even more.
To it, but there were
Okay.
some set of meters that,
Right.
which that was potentially true.
Okay. Okay.
Yeah.
I believe you, I just don't remember it.
It's,
Okay.
we can get some more commentary. Did you have something, Senator?
No, I'm just trying to, yeah, I'm just trying to think of why a meter would do that, probably where the input is, but.
Yeah, it makes me wonder if it's just seeing the passage of electricity rather than the direction.
Right,
Yeah,
and behind the meter, in front of the meter.
yeah. Anyway, we can. Here, it
What's up?
is worth circling. Okay.
All right, so still on page 2, subsection B. First, the provision regarding a notification form has been struck. So it's not there anymore. And then this language, what was the prior C? The installation of a portable energy generation device that complies with subsection A, meaning it's up to 1,200 watts and connected to a smart meter, shall not be required to comply with the requirements of section 248 or be required to obtain a connection agreement. So that hasn't changed, but the clarification of a distinction between the device itself, but a device that applies. That is what gets you out of needing a interconnection agreement. Subsection C, that same language has been added, so a electric distribution utility shall not require a customer using a device that complies with subsection A to obtain the company's approval, pay a fee or charge related to the device, except where the customer is responsible for damage to the electric grid. So that's new language that was, I think, requested by the utilities. And then install any additional controls or equipment beyond what's integrated into the device.
Yes.
I'm a little concerned with that language, except where the customer is responsible for damage to the electric grid. Who determines that the customer is responsible, and what does that I mean, I remember them saying that, but it just feels like it's overly broad and vague, but I don't,
I think it's a good question. How is that determined?
yeah.
I feel that, we talked to, I feel like you had some thoughts on this one.
Well. I assume it's the utility that is responsible or owns the line would be doing investigation on that. I haven't, I don't know specifically, I don't know if ISO is involved at all, but,
I mean, also, if the utility doesn't wanna know, and I even wrote down. Bruce Porter does not want to know. It's very funny, if they don't want to know, how will they know that somebody's getting this device to say, oh, you harmed the grid some way and you can't have one like that? It doesn't seem to fit with the process.
Well, and I can imagine that it would only likely do that if they were somehow not complying with UL 3700. Terry, oh, I'm sorry, Senator Williams, you had a thought.
I was thinking that, you know, if you have more than one device in an apartment, how you gonna know which one contributing to it?
Yeah, it's fair. I am okay striking that if it makes it, if it introduces less confusion.
Yeah, because I think that the fee that someone might have to pay to, if they've done damage to the electric grid.
Right.
The fee that they would have to pay is for the damage, they shouldn't have to be allowed to charge a fee for the.
For the device.
Yeah, they shouldn't have to be allowed to charge a fee for the device, for the,
Yeah.
for plug-in solar, and that's what it looks like. It's like, oh, you damaged the grid, so now you have to pay us for your plug-in solar thing.
Right, like here's a fee for the device.
Exactly, so that
That's-
seems counter to what we're trying to do.
Yeah, and even beyond that, we're we're encouraging people to do this, and if they do it within the confines of the law, they actually shouldn't be responsible.
Right, it's fair, that's a good point too, yeah,
It's if they plug in too, then they are.
they go beyond
Yeah.
1200,
Right.
yeah.
But if they're operating in conformance with the law, I think would almost be saying the opposite.
Yeah.
Yeah.
It's because maybe the transformer blows because there's 400 of them on, so we can plug in one more and, you know, and that's not, you know.
It's not your fault.
Yeah.
Yeah, or their
Yeah.
fault.
It's cumulative.
So. I don't know, maybe for now, mistake that.
I'm good with that.
okay, I did wanna talk about adjudication of issues briefly too.
If you
I
think
don't know where we're at time now.
we are, I think we should just keep going.
So. Do you wanna talk about disputes right now, or you want me to keep going? Keep going,
Actually, I think we should.
Is Maria waiting? Well.
Yeah. Okay. You don't know, is Maria joining us virtually?
No, she's right.
She's awesome. Okay. Right, well, let's keep going. Okay.
So there's some new language in subsection B at bottom of page 2. A customer with a net metering system shall not also install a portable solar energy generation device. As portable solar energy generation device shall not be eligible for net metering. And excess generation fed back into the grid by a portable solar energy generation device shall not be compensated.
Yes.
And this, I think, we talked about saying compensated by the utility. Because. I mean, compensate, maybe this is not necessary, but I was just thinking, they're compensated by getting additional electric from their plug-in portable, they're compensated by the actual solar panel. So it depends on how you think of compensation, like compensation can be like, you're getting good things, you're getting energy. maybe it doesn't matter, but it seems to me like it's gotta be clear that they're not getting money from the utility company. Okay, what else?
That's fair.
On page 3. Subsection E hasn't changed, this is about a generation device in a public building needs to comply with the building and fire code. So sections 3 and 4 are new. These are both sections related to, entities preventing solar generation devices. So section 3 is amending 24 VSA 4413G, so this is part of the zoning statutes. And so, notwithstanding any other provision of law, to the contrary, a bylaw, so a municipal zoning bylaw, under this chapter shall not regulate the installation, operation, and maintenance of a portable solar energy device or on a flat roof otherwise complying structure, solar energy device that heats water or space or generates electricity. So there is already this prohibition that municipalities can't regulate on flat roof or other structures, solar energy devices. This is making it very clear that these portable solar energy devices are also included in that, so bylaws cannot prohibit them.
Oh, yes.
Does this also include the bylaws of sort of like a private,
Yeah.
HOA or some private organization?
We're getting there.
That's the next.
Oh, we are, that's,
Oh, yes. The 24 VSA in the 4400 says of municipal zoning bylaws.
okay,
So just what a municipality puts in their bylaws. Section 4, though, is amending other types of agreements. So Title 27 is the property chapter. So 27 VSA 544. There's already this provision about energy devices. So no deed restrictions, covenants, or other similar binding agreements running with the land shall prohibit or have the effect of prohibiting solar collectors, clotheslines, or other energy generation devices based on renewable resources from being installed on or appurtenant to buildings erected on the lot and 4 parcels covered. So we can just stay there for a second. So there's already this existing provision, deed restrictions, covenants, and then similar binding agreements are related to HOAs and other housing structured documents. There is already this prohibition that they can't prohibit solar collectors, clotheslines, or other renewable energy devices. But it's for being installed on the building. Portable solar has different configuration abilities, so it could be on the fence line or in the yard. So appurtenant to is a property term that is used in statute, meaning adjacent to or a part of the home. So I think it should cover the curtilage, but the area around a homestead. Yeah, I was showing off.
What's that word?
Yes, the curtilage around your homestead is like the adjacent parts of it. Appurtenant to the building,
Like the yard?
yes.
Wow,
Okay.
that's a new.
That might be part. That is part of it. Property law, man. Those definitions are used elsewhere in statute.
It's getting us used to them.
Yeah. So I thought that was the easiest word to use appurtenant to because you're talking about different.
I also found the lights.
Great. And then finally, in this still the same section on page 4, it strikes the reference down on page line 17 that this section shall not apply to patio railing and condominiums, cooperatives, and apartments. So I struck that language because you are interested, I think, in railings and patios. After I drafted it, I do think perhaps instead of striking the whole thing, we could insert portable solar there if you. Instead of just striking the whole thing, but we can talk about that.
I'm sorry, you're talking about this last sentence?
Yeah.
are you suggesting it could say this section does not apply to portable solar or whatever? we're
Yes,
calling it?
yes, because I do think. Yes,
What does what is
Oh, I
this
guess,
section?
so I can read, so the legislative intent in enacting this section is to protect the public health, safety and welfare by encouraging the development and use of renewable resources in order to conserve and protect the value of land, buildings and resources by preventing measures that will have an ultimate effect, whether intended or not, from driving the costs of owning and operating commercial or residential property beyond the capacity of private owners to maintain. So this is the intent section for this whole section about condos or other just developments cannot put in deed restrictions that prevent renewable energy systems from being put on there. And then the intent section was added to reflect that it's in the public safety and welfare, which is the police power that the state has to regulate. So this section overrode the private ability to contract. So there's an expression of intent here about that. That helped
Sort of. I mean. Is this section about? Like condos can't. Prevent you from putting up. Like putting in a heat pump or something like that.
Yeah, the first part above this, yes. But then there's a section at the end that says the section shall not apply to patio railings in condos, cooperatives or apartments. And so the language in the statute above is talking about on the building specifically, these condos cannot ban solar. This is saying it doesn't apply to patio railings.
Okay, yeah.
So like as the law exists now, the condo association could say, we are gonna regulate your railings. For renewable energy,
Yeah.
I mean, it's like you're taking it out. And. It seems like doing both, being like. Positive, saying this. Or maybe it's saying you can't prohibit solar and this apply to railings, or you can't prohibit the plugins. Yeah, it doesn't apply to railings. Is that necessary to do both, do you think?
I don't think so, but in this. I think I need to rewrite that sentence instead of just striking it, is what I was sort of saying.
Oh, okay.
Yeah. Yes, I think I had some previous confusion here, I'm sorry. The next draft may be slightly different on that, but that's the end of the bill. Yeah. Yeah.
sorry, I missed that last.
I'm making it more confusing. I might rewrite that last sentence to make it slightly more clear.
Oh, okay, okay.
Instead of just striking it.
Okay. Super, so. There's, did you wanna talk about, adjudication?
Yeah, do you wanna ask the question on so
Well, so the context here was that we had some testimony saying that the distribution utilities were requesting that that we make it clear that any disputes go to the AG's Consumer Protection Division as opposed to, I think it was Cap E, but I am not familiar with that. Organization division, and so, and particularly because we're treating this like an appliance. And that's where complaints ought to go. We didn't end up putting that in here. Do you want to speak to that?
yes, because I don't think I saw that testimony, but I don't know. Who adjudicates a dispute between people is based on the type of dispute it is, who are the people at issue here. If there's a flaw in the product that does seem that could potentially be covered by the AG's Consumer Protection Program. But if there's a dispute between whether or not the customer who has installed a portable solar system, they have a dispute with their utility. I think that the Department of Public Service and the Public Utility Commission would already have authority to adjudicate those decisions. So 30 DSA 208 is about complaints and investigations that both the PUC and the Department of Public Service can open against utilities, because they have a lot of jurisdiction over the regulated utilities. And so if a customer has a complaint, they can bring that complaint either to the Department of Public Service or the PUC, who both have authority to investigate a dispute between a customer and their utility.
So it sounds like we don't necessarily have to say anything in this draft, because if it's a complaint about the device, then it would go to the AGO, and if it's, like you just said.
I don't think, yeah, I think so,
Yeah,
but I'm at work for the Attorney General's office, so I know that they know what their jurisdiction is, so. But like a general consumer product, they have a lot of authority over consumer protection issues.
At this moment, I'm okay with leaving it as it is, though I'm sure if there's strong feelings about that from other people, that we will hear about that.
You can take it, but with that might happen.
Right, without mentioning. Adjudication, where it ought to go. There was one other thing that I think is worth mentioning, which is, on page 2. Line 16 and 17, this distribution utilities are not allowed to require that people install any additional controls or equipment beyond what is integrated into the device. I just want to flag that as because one end of the spectrum there is that we say, in order to have one of these devices, you need a receptacle that complies with 3700, or that's one issue. You may need an electrician to check out in order to comply with 3700. So I just want to flag that's something that we may want to talk more about. I think as it is, it's okay for now, unless folks have other thoughts.
well, I mean, based on what I understand from the testimony we received from the electrician folks. They don't know what's in 3700 yet, 'cause it hasn't been totally decided, so. I feel like we shouldn't add something to the bill speculating about what it might be. Cause it might just come out saying you don't really need anything, these things are kind of just like a toaster.
Right.
Or if they do say, actually, you need a special plug like you do with a dryer, then
Right.
that we would have to change that.
Well, but on page 2, that's about what the utility itself is allowed to require, not what is required under the UL.
That's fair.
Well, and on page 1, line 17 and 18, it does say that they have to comply with UL 3700. And so there may be things in there
Right,
that specify you need a special receptacle, you need a dedicated circuit, like whatever, like that. It may just be contained within that.
right, so I don't think we should have the utility say they should do that.
That's fair. That's fair.
The reality is that people in order to do this are required to bring an electrician to get another thing.
Yeah, nobody's,
Yeah.
people aren't gonna do it.
Yes, dedicated circuit means electrician.
Yeah,
Make
right.
it longer
Right.
because and
People
longer
are-
because it's hard to get an electrician.
Right, well, people aren't gonna know if necessarily.
Whether they even have.
Right,
dedicated
right.
circuit.
Yeah.
You're catch.
Yeah,
Okay. Any other thoughts on this, your team? Okay, I do wanna mention for your sake, Senator Williams, because I know you had asked about the implications of this for homeowners insurance. And so I did chat with one of the lobbyists for property and casualty insurers, and they've submitted a letter. So that's now online, so you check that out.
Okay.
And it's basically, if I was to summarize, it was that this is a new product. We don't have any problems with this now. If there are problems, we will address. So, yeah. I hope that's a fair paraphrase to anyone listening. Okay, so anticipating that we will be looking at another new draft, tomorrow. That's the hope. And I think that's on the schedule for tomorrow. Is that reasonable?
Yeah, you only requested a little thing.
Okay. And then if there's anyone listening who would like further changes, certainly let me know, please be in touch. Discussion. Okay, I think that is. Okay. Okay, super, thank you. We'll see you again. Okay, huzzah. Okay, so I just want to give the committee a heads up that, good morning, welcome. That we have a variety of topics today. We're kind of all over the place. Yes, come on up. So we are introducing a new bill this morning. It is just a study about green banks. Morning. Good morning. So I suppose I can give a little introduction, and then we have Maria Royal with us today, Village Council to. Thank you so much. Very happy to be here. So just as a little bit of context, a number of constituents came to me asking about the possibility of the role that a green bank could have in Vermont and the potential benefit that a green bank could have. Similarly, people are also asking about public banking, of which I think of green banking is sort of a subset of that. And so in doing some research on this, discovered that as a part of the treasurer's climate infrastructure report, they had a recommendation to further investigate the role of green banks. And it is complicated by the fact that we have a number of lending institutions in Vermont already that do some aspect of what a green bank might do, but there's nobody who's doing all of the kinds of things that a green bank could do. So since there was this recommendation in the treasurer's report to look further into the potential of a green bank, that is exactly what this bill does. It just says, let's further study it, see what the potential could be and how it could be structured to benefit Vermont. And yeah, there's more I could say about it, but well, I'll say a little bit more, which is just that I think of fundamentally, you could think of the climate crisis as a financing problem. And so if this is a vehicle for us to help finance a transition, I think we could use all the tools available to us. Right, go ahead, thank you.
My work is done. So again, Maria Royal with the Legislative Council, so it's S-174 is the bill number. And we will walk through that. And the treasurer's report, I believe you're going to be hearing testimony from the treasurer's office tomorrow.
Well, I think that got pushed back, unfortunately, but
Okay.
Yeah, so we actually have no further testimony on this today,
Okay.
unfortunately, but
Okay.
there we go.
No problem.
Yeah.
I just wanted to mention, that Jude has posted that report. So if you want to actually look at it, it's 2024 report. And just as a reminder, that report came about in the legislature in the big bill in 2023, so fiscal year 24. You asked the treasurer to basically see how various financing efforts could be coordinated, so existing efforts in the state. See how various entities, state and public nonprofit entities could draw down, maximize as much federal funding as possible. And then finally coordinate the deployment those federal funds or any other funds. So that was the overarching charge. And the report came back with 8 recommendations. One of them is the study taking a further look at green banks, various models. So I just want to provide quickly that context. And now we'll just kind of walk through this. So section 1, the treasurer shall conduct a study of green bank models implemented in other jurisdictions to determine whether and if so, how implementation of any elements of such models in Vermont would benefit the state by facilitating and accelerating investment in climate mitigation infrastructure and farming and agriculture in a manner consistent with state goals and policies. And Senator Watson did add farming and agriculture, wasn't initially, but not part of the what the treasurer looked at, but that's something to also be considered in this context. So then the basis of the study shall reflect its recommendation 5 in the treasurer's report. Accordingly, the treasurer shall consider the creation of standalone financing entity, the green bank, for the provision of green bank-like authority to one or more existing state entities. And then there's a reference to the definition of a green bank in the report. And the report basically acknowledges there are many definitions, many models. So part of the challenge is coming up with what precisely is meant by or what would like it to mean. But just for example, the definition that was kind of initially floated back in the report specifies that a green bank does not take deposits. Rather, they function like loan or investment funds, using a wide array of financial tools to support investment in clean energy infrastructure. There are various governance structures. Sometimes they're fully public standalone entities, other times they're quasi-public entities. Not profit maximizing, but basically trying to increase the amount of financing available, whether working with private partners or otherwise. So that's just kind of the general definition that was looked at. So, and then that's you can see on line 7 of page 2, basically reflected in what's the term green bank reference there. So then subsection B, in conducting the study required by this section, the treasurer shall seek input from the Vermont Public Finance Climate Collaborative, the Vermont Climate Council, the Secretary of Natural Resources or designee, the Commissioner of Public Service or designee, the Vermont members of the Coalition for Green Capital, Secretary of Agriculture, Food and Markets or designee, and any other public or private stakeholders deemed appropriate by the treasurer. In addition, the treasurer shall establish a mechanism for receiving written public comments and shall hold at least one public hearing on the treasurer's draft findings and recommendations before they are finalized in a report in the General Assembly. And then subsection C, in designing the structure or approach that would achieve the greatest effectiveness in Vermont, the treasurer shall consider the value created, possible trade-offs, potential risks, long-term sustainability, coordination among existing state entities, the short and long-term economic impact, including with regard to funds retained or recirculated within the Vermont economy, opportunities for maximizing the availability of public and private funds, and any other considerations deemed appropriate. And then D just specifies that the recommendations should be filed in a written report for the relevant standings and things, and that report will be due December 1st this year.
Any questions then? Yes.
I don't know that I have a question, but I would just suggest that we hear from VITA, because I think they do a lot of this work already. They have full funds that are specific to this kind of work, so they may have suggestions.
Yeah, and I think it's worth hearing from, there was a number of entities that have had to do something similar, so he's working.
Yes, Sustainable Jobs Fund, the HCB, there are a whole bunch of entities that do this kind of thing in one way or another.
Yeah.
So
So looking at what the offerings are, and possibly then what the gaps are. Yeah. Great. Okay,
Any other questions for me?
I think that's it. So we're just introducing this today. We'll take hopefully some more testimony and.
Okay, I'll just add that there are lots of reports that go over all the different models. If you want, I can send them to Jude and post them. If you want to start taking a look yourself.
That would be great.
Okay,
Yeah,
sure.
thank you so much.
You're very welcome.
Yeah, super. Okay, we'll be on time. Okay,
We're a little bit ahead of time.
that's great. Well, maybe let's take a break until we're joined by legislative.
All right, we're live.
Okay, all right. This is Senate Natural Resources and Energy coming back from a break. And we are considering S218. I think we're would like to take up a vote. We have our lunch council here with us. If you want to come up, that's great. I don't think we have any adjustments. I think we were otherwise.
I looked through the bill this morning to see if there were any dates or anything else. I did not see anything.
Okay.
Salt bill.
So, no. Just take a minute. That's all.
I had one note, but I think we settled it.
Oh, usage versus application.
Yeah, well, the salt alternatives,
Oh,
and whether we wanted them to report on that, but I think we decided no, because
just
the point is salt.
Mhm.
Yeah.
Okay, if there's no recommendations or altering it, then I think we're good to have a vote. Are we ready? Ready to go? Okay, then, my goodness,
So
secretary,
motion.
clerk. All right, the clerk shall call the roll.
Okay. Senator Batch, yes. Senator Bonner,
Yes.
Senator Hardy,
Yes.
Senator Williams,
So,
Senator Watts,
Yes,
4-1-0.
okie dokie. Super. Thank you.
So it's gonna go to finance and for, I believe,
Yes. Yep, so finance or a fee report
Yeah.
and
the cost of the program.
yeah. Which is yet to be,
Right,
right,
there's a contingency clause.
Right, exactly.
Since.
okay, so that'll come out anyway.
We get more time with it.
You're welcome. Well, I think it's likely me. I think I gotta do it. Yeah, sure, so. All right, to be continued. I think that's it for 218. Congratulations, team. We just got the second time with salt, but first bill of the year, so huzzah.
You want me to talk about anything else?
I think at this point, we are good. Unless there's something that is on other people's minds. Oh, actually, since you're here. And I had emailed you a question. Thank you for pausing long enough for me to remember this. So coming out of our discussion yesterday on 212, which is about creating a general permit for water and sewer, possible, it's a kind of delegation to municipalities. We did hear from the department that they are creating their own general permit based on a manual that they're putting out as an RFP. And so I had asked the question, did you think that they had the authority to create such a general permit under their existing authority? Would you like to share?
Sure, so the department basically operates under two different chapters when they are permitting some of these non-direct discharge systems, these indirect discharge systems. So for smaller ones, potable water supplies, wastewater systems, that's under one chapter, and that chapter does not give them general permit authority. The other chapter, the indirect discharge, which is usually the larger systems, community-based systems, that does give the agency general permit authority under that chapter. There is this little bit of an ambiguity in that they can identify minor permits or minor actions and deal with them in their rules, but it doesn't say general permit. So I was trying to watch the testimony from yesterday, and I got right to the beginning of Brian Redmond before I had to come over here. I will try to figure out what Brian is asserting as authority for that. I mean, I heard the testimony from Chris Cochran and John Groveman about coming up with the manual and coming, Chris Cochran said amend the rules generally, they need to be modernized, etc. I don't disagree with that. I think that's The manual for connections, that's one thing, they can do that on their own, that's just guidance, just go do that as guidance. But modernizing the rules, that's gonna be a heavy lift, I think, that'll take.
To modernize the statute.
Modernize the rules.
Oh, the rules.
Most of that program is run through the rules. And the rules are over 200 pages. And then they have this directive to confer with what's called the technical advisory committee, who's made up of experts, but the agency and the technical advisory committee don't always get along, even though they're largely ex-agency people. And so that takes time, because they have to run their rules by the TAC, and the TAC, that means it's going to take some time to come to consensus.
So if they have authority to do a general permit, or if we give them authority to do a general permit, do they have to redo do they have to modernize the rules before they do a general permit?
No, I don't believe that they do. I think when I was listening to Chris Cochran, I think he was talking about modernizing the rules in general
Mhm.
and not just for connections. Yeah. And also, you can make the changes for connections faster than the agency can make them. It might be surprising to you, but you will work a lot faster than some of these agencies do. And
Yeah.
and I don't mean that as criticism of Brian Redmond's division, because they are, as I've said before, the division that issues the most permits at DOC. They have a significant workload, and it's a difficult subject. And they have to go through the TAC, and then they gotta go to the public. It's gonna take them time. You can work much faster than that with that regard, and plus, depending on what Brian's authority is it discretionary or mandatory? I doubt it's mandatory. I doubt he has a mandate to take a general permit. If you want a general permit for this, that's your prerogative. You're the supreme policy, law and policy maker. So if you want to exercise that supremacy, that's up to you.
So given that, it's, I'm happy to have more conversation about the direction of that bill, but it seems to me that, you're gonna watch the rest of his testimony, assuming that they don't have the authority to do that general permit. And that was gonna be a very effective way of helping the state move forward. I would love to cover those bases for them, make sure that they have that authority. And yes, go ahead. Oh, and direct it to happen. Yeah, that's fair. Not just giving them authority, say, we go do this. And yes.
I'm sorry, you were.
No, well, I was gonna say, and it would be great if we could start addressing modernizing the rules, though that may take more time, even on our side, to understand how they need to change. I want to get that clear, so that we're not misstepping there. But Senator Hardy and then Senator Williams.
Yeah, that's basically what I was gonna say is, I agree, we can work faster, and that was sort of my point with the William posting thing too, but yeah, I don't know exactly what we do, what we're supposed to do, and I would need guidance from the department and you, Michael, to tell us what to do.
What needs to change depends on the job.
Yeah, that's always the case.
Isolation distances, connection changes in use, occupancy standards. Flow standards, there are multiple people out there with different ideas.
Yeah, okay.
And then you have to remember that the agency has long asserted that their approach It's a science-based, health-based standard to protect public health and the environment. To the extent they think is necessary. Which is. Probably. A little more restrictive than other states. And so you will hear, why don't we do it like New Hampshire, why don't we do it like Massachusetts and. Agencies will say, well, we have a health-based, science-based standard that we think is more appropriate for site specific. Wasn't somebody in here saying if you have it at the top of the hill and if you have it at the bottom of the hill, then you have to look at different.
Yeah, there was Stone, was talking about that,
So
getting
you,
water up the hill.
right. Other states, it's just X feet. Well, X feet doesn't necessarily look at slope and. The type of system, type of system at the bottom of the hill. The agency is very. They like their health-based, science-based standard, and so they get a little defensive.
It's hard to argue against health and science, but. This might
People
be,
do it.
but people do it, and. At the same time, it depends on what you mean by that, obviously, the devil's in the details. But this feels like a wrap.
Yeah. Senator Williams.
Just in general, I don't understand, once rules are made, an agency's designated as having rulemaking authority. And then they enact the rules and they're actually executing that. How can they just undo it without going back to the legislature?
Well, it depends on the grant of rulemaking authority that you give them. And the grant in this program is pretty broad because it is a very technical. And fairly expansive program, so. They have the authority to amend their rules as they believe it is necessary to implement the chapter. So if they find an issue. They can resolve it without coming back here because you've already given that broad authority. And that's kind of a. I mean, how many of you are on UPCAR or have them on UPCAR? It's like that was the debate, how specific must the grant of legislative rulemaking authority be, And that's kind of an inherent debate in government. It's like, do you give the experts really broad authority, or are you circumspect in what you give them and are very specific about it? I get debated either way.
So, okay.
So this is kind of off the subject, but it goes back to another bill we've got in here about waypoints. They already designated certain lakes as being, having boundaries that they can stay within. Now, all the other lakes are coming up and saying, we want to get involved in this from way in. So do they just have the authority to make rules to include those other entities?
To include them how? So in the prohibition on rainbows? Yes, technically they do. They have pretty broad authority to regulate use of waters. They can designate what vessels are allowed to use waters, where certain vessels are allowed to use waters, and what uses can be allowed in certain areas of lake. I mean, leaving rainbows aside, the water skiing rules are really specific on some lakes, like where they can do it, how fast they can go. So it can get really specific.
Okay.
So I was thinking about a draft. And I think,
For 212.
yeah, so I think there was a sense in the community that the building go into a general permit with a presumption that if it's by engineer, it's engineer and installed properly, the state made the repository for the next impacts. And it's still doing a delegation for those, all of those sense. I think we were all specific things. So surprised at how few permits there actually are, how many probably how few municipalities are actually interested in taking this over, but leave that in, so I think that's kind of what's good for the next project, thank you.
I think that's kind of what your bill already does.
Well, however, we were actually, I think, directing it to have. It's maybe not right.
Right.
So what happens?
Does the bill mention the general permit?
It does mention a general permit, but it is also, it's as a petition by the municipality to. And so if this is, we're just removing the petition by municipality to say this isn't. This is something can be.
Right, I mean, you could do it either way. You could just say the agency has the ability to adopt a general permit for the connection of wastewater, potable water supply systems to a newer or existing structure, including the criteria for connection and the requirement that an engineer approve and submit the application or the certification of connection to the agency. The Senator Barnard's made a specific point in that some municipalities might not want to do that.
Mhm.
They might want it to keep going like it is. And how do you resolve that? It's resolved in the bill through municipality has to apply for delegation, and then there's that general permit where that they implement. But I think you could probably resolve those questions in another way. I can talk to Brian if you would like on that then.
I think that'd be great. So let's anticipate that we're gonna have a new draft based on the direction that they are already going and wanting to direct them to do it
Right.
and giving them the authority to do it. Unless we discover that, somewhere along the way that they haven't, but assume that's not happening.
So my takeaway is to make sure that they have the authority to do a general permit. Revise the bill so the bill is moving towards the approach that they are using in their general permit. And then I think the only other question is the money, the fee, like, how much do you charge for that? And I'm not sure if Karen Warren would testify as to, how it can be duplicative fees, municipal versus state, whether or not you want to retain that, or whether or not it does involve both municipal and state oversight, and therefore duplicative pieces.
So, didn't get to it, but Brian, I think they were suggesting just 550.
But
That's what Brian was suggesting, but Josh Hanford, who testified for VLCT, was like, if towns are taking this on. They have expenses for doing it, and they would like the authority to charge the fee. So is it, and 500 is higher than a single family home, but way lower than all the other stuff. So is that the right amount? That seems like not the right amount to me, frankly. So how do we integrate it flat without double fees, doubling the cost of fees, but towns need to be able to cover their costs, otherwise nobody's gonna do it.
right, and if you alter the fee for connection to the agency as it exists now, you're potentially altering their budget.
Exactly.
And
Mhm.
what does that do to this division's budget? And in a year where they will tell you they are understaffed and they don't have the money to staff.
Yeah.
So,
That feels like an open question to me right now, yeah.
I was gonna say, that's what they suggested, we actually do the 500 flat figure, because raise the issue of being a little bit more than it's currently for a single family home, a lot less than it was, maybe there's some stagnant fee, but it's a lot less than it's been, because it's, and they haven't, they set themselves up to saying,
But also sorry.
Go ahead.
The fee, my understanding is the fee, that the 500 fee is only for if a town decides to do it on their own. if it still goes through the regular process, it would be the fees as they exist now. And what we heard from town, from VLCT was they don't actually know of any town that wants to do this right now. Maybe Burlington, and they were gonna ask. But so it might be, we're arguing over fees for no purpose, because nobody's gonna do this.
Well, that's always been the dynamic, somebody comes in, the Karen Horn representing her organization or the city of Burlington or. Representatives of certain cities and they say, we need this. Administrative burden to go away, and you do something. And then nobody takes it up.
Exactly.
Um,
I mean, the Stowe guy was like, no way it would be.
Yeah, I am interested in ensuring that the municipality has the authority to charge whatever it costs them to do the fee. I think that
Yeah,
in addition to whatever fees the state is charging, that seems reasonable to me, but I think that's something that we should hear more about and let's do some more thinking about what the right situation is.
It's interesting, I hadn't picked up on what you just said, that it was only if this, I thought they were just talking about whether it was across the board, I wondered about the impact. So your point is right, that probably doesn't matter.
They're willing to take the hit.
Saying 500 is fine, because yeah.
yeah,
Okay.
exactly.
Okay, thank you so much.
Thanks a lot.
Okay, we are gonna take a break, we're supposed to be back by 5 minutes. Yep. Let's take a Okay.
And Karen and Nick.
Okay. Okay, all right, this is Senate Natural Resources and Energy coming back from a break, and we are taking up S 138, which is about commercial pace, and I want to give a little context here. I've had a conversation with the chair of finance about where the bill belonged, or who had time to take it up, and nobody has time, and it's tough in that regard, but if we agreed that we're gonna, if we're gonna move forward, we're gonna try to take a first crack at it, knowing that the draft that we're looking at right now is, well, I'll just say I wouldn't pass the draft as it is right now. But with that in mind, and with hope that we can eventually get it into a point that might be more palatable. Wanted to continue to take some testimony on it. So we are joined by, I don't want to say your last name incorrectly, Aaron, correct?
Parents, friends of parents.
Parents, oh, okay, all right, from DFR, welcome.
Good morning. Madam Chair, members of the committee. So I'm Aaron Ferris, the Commissioner at DFR for banking. Just had a few comments on the structure of the bill of draft 1.2. So if you are following along, I can just kind of walk you through those. And I think it looks like a lot of the language was just copied from the residential PACE program. And when that came out a number of years ago, there were some pretty strict requirements. The department wanted to make sure that residential consumers were not harmed by some of these transactions, and so there was language about strict underwriting guidelines written by the department. When we're thinking about commercial transactions, I don't know that that's necessarily appropriate for DFR to get into underwriting those types of transactions. So I would in section 3276. At the end of paragraph A, there's a lot of language regarding the municipality shall follow those underwriting guidelines established by DFR. I don't know if that's going to be necessary.
Sorry, can you say where it's 3276?
Sure.
And then
The last two sentences of that large paragraph, paragraph A. So starting on line 15 through line 21.
okay.
So that essentially is saying DFR needs to write some underwriting criteria. And then this municipality needs to follow those set of criteria. So
Okay, so take out basically line 15 to 20.
I would think we don't need to get involved in doing that. Typically, commercial transactions are a little more of a, people's homes are not at risk. These are, warehouses, other types of stuff. But this is a little more sophisticated inside of the home.
Good, great, thank you.
Let's see, additional comments I had involved, let's see, on page 6. It's paragraph 7, subparagraph B. Property owner shall provide to the holders of any existing mortgages on the property notice of intent to enter into an agreement. A lot of our banks and credit unions are involved in financing commercial properties, and it might make more sense that there's some sort of approval that the existing mortgage holder needs to provide for that transaction. So that could be strengthened to include that. I think that would come about just the way that a lot of these transactions are financed in Vermont in general.
Sorry, so making sure that I understand, so include some kind of approval of who now?
The existing commercial mortgage holder.
Oh, I see. Yep. So instead of are you thinking in addition to the sentence that's there, or just strike it and replace it?
Probably in addition is fine. Providing notice that they intend to enter that is helpful, but then also making sure that it's that a set to the transaction itself. And then. I just identified as sort of an inconsistency in the language that you have in this entire package. At the bottom of page 6, it says in paragraph H, there shall be no penalty or premium for prepayment of the outstanding balance of the assessment under this subchapter if the balance is prepaid in full. Then if you go towards the end, we've added in section 46, the explicit exception that would allow
Page,
page 10. Actually, well, it's really on page 11, but it's starts with page 10. At the bottom of page 11, we've added this exception, number 5, obligations incurred for commercial property sets clean energy projects. We've added that as an exception to Title IX, Section 46. And Section 46 essentially allows commercial transactions to charge the prepayment penalty. So we've added that exception over here, but then explicitly stated in the beginning that it's not allowed, so. However you want to make that policy choice, it's up to you.
Okay.
See, one other comment, related to the sort of notice in the assent comment that I said, on page 10. Starting at line 10, we've added a lien for an assessment under subchapter 3 of this chapter shall not be subordinate to all liens on the property in existence at the time the lien for the assessment is filed on the land records. I think that would also, unfortunately, upend commercial mortgage financing in the state if these properties got that sort of priority in that regard to existing mortgage holders.
So you would recommend striking that whole additional new sentence?
That's correct.
Okay.
That's correct. I would, I believe in the residential program as it is now, there is not that same language, so the existing ones still has priority. Before the commercial.
So can you just say that one more time? So the existing,
Mortgage holder should retain that priority in this chain of.
okay. Okay,
Sorry to jump around.
no, it's fine. It's super helpful to have like highly specific. Yeah, technical comments, it's very helpful. And with the logic to go with them.
That was the extent of my comments. I don't know if there are any additional questions that you have.
Yes, go ahead.
Just in general, I mean, I thank you for those specific comments, and in general, is DFR supportive of this, or do you think people are gonna use it, or?
I would think our official policy is just neutral, like, we're okay with if you want to go in this direction, assuming you make these changes, that's fine with us. If you don't, we understand. So yeah. I guess neutral to support it.
That's
changes.
Fine, and do you think it's a tool that would be used in Vermont?
I think so. The residential pace was slow to be adopted, if at all. I think at one point I heard there was maybe 15 transactions ever written. Going back in time, that started out right after the great financial crisis. So there was a lot of people in mortgage markets. There might have been apprehension about that now. Commercial borrowers are generally a little more sophisticated, can see that, paying for these changes up front will save you over the long run. So I do think there's probably a market for this.
I don't know if you're the right person to ask of this question, but if this constitutes a special assessment that gets paid back through property taxes, is your sense that, if somebody wants their property taxes abated, can the abatement process apply to this lending structure? Does that make sense?
I probably does. I don't know that I would be the person.
Okay, all right. Okay, that's. That, I would think not either.
We want to make sure
I think the section should be
part of
clear.
your conference.
You know, I think there's probably a third party that would ultimately be financing the actual projects themselves and just being repaid through that assessment, so I don't know.
Right, well, and I think that idea is not actually captured in this, and I wanna make sure, we're gonna need to amend this to ensure that that can happen. And anyway, I'm just thinking ahead to how would that, just the rules around allowing that to happen, so. Okay, any other questions? Okay, thank you so much.
Thank you for
Yeah, for sure. Okay, and we're gonna go to Mr. Sherrick. Welcome.
Thank you. Thanks for having me. For the record, I'm Nick Jarrett. I work for Downs Rackman Martin. And my interest in this, I have a client named Mike Davidson, who I grew up in the Upper Valley, he's a developer that's been responsible for a bunch of the revitalization work. In Waverly Junction, he calls himself a redeveloper because his niche, as he sees it, is finding old buildings, repurposing them, office space, housing, things like that. He is obsessed with old buildings. Sees the value in recycling that space, building space. Last year, we purchased the Goddard College campus over in Plainview. A grand vision, for restaurants, arts and things, but also a big house piece of them. And he reached out to me because he's also developing a project right now inside of Saratoga, New York. And using C-based financing to do really cutting edge stuff for the energy efficiency work. And it's kind of big success to have in the program. And his question to me was why aren't we doing this? So because I understood it better, it's a really interesting policy piece to me because of this wide adoption. I'm sure with something like 40 states right now that have enabling legislation, and that would, be clear, include Vermont. We don't have an active C-based program at the commercial level. DC also has a program. But I think relevant to this committee as well, it's worth pointing out the thermal sector is responsible for a huge part of our emissions. It's been one of the challenges to move the needle around. Without speculating, because I wasn't here, but our previous efforts sort of residential focus around base in Vermont made that choice for whatever reason. I would argue that it wasn't adopted widely because a homeowner like myself, the sophistication of going through something like this, some better rundowns, some spacing. I'm not going to pursue that. But in a much larger scale, a developer has the resources, sophistication, and the team to look at how it passes out on projects. And they see the value of doing this type of work. It saves the costs over time, makes it more attractive. And the appeal is C-based, you get financing for that at a rate that's reasonable over a longer period of time. It's also attractive because it gives access to capital. It's not within the state necessarily. So national groups that love financing these projects. And the reason they love financing is the fault rates are next development does the job. It follows the model. So we're a project go under. In most cases, it would be something that's down the road, back payment following projects. So really, I appreciate having me here. I'm not an expert in this policy, but I know folks who, to your question, Senator, about whether this would be adopted, I can say with some authority, who's chomping at the bit to get going with this. And I can also, like demystify the situation. People love to come in and talk to you specifically about what he's hoping to do in Vermont, but also what the experience has been like New York and elsewhere. And then because of his work, he comes to have access to things who are experts on this, both on the finance side and the implementation side. So I'm personally thrilled with me taking this up because I spent a lot of time thinking about it. I really do think it's sound policy for the state. I think so many things we do in Vermont without. But editorializing for further, but we take pride in some ways in being cutting edge, bleeding edge on things. I don't see this as a piece of implement. I see this as something that's worked very well elsewhere, we have plethora of examples of experts to talk to. Why it works, why it's value. I do believe there's some affordability, a lot of housing prices talking about emissions, but a lot of work on this committee around issues of that nature. I see this as sort of a nexus of those challenges, not a panacea, but a tool to help with the needle, a lot of positive directions. I do think the residential focus on that well meeting was not effective, and we've seen that trend, but opening up to larger commercial, bigger projects, creates some opportunity for the state, but I really do think the details matter. And doing that consultation, working with folks, looking at what's worth for states, that would be my strong recommendation for what that's worth. I don't need to belabor further, except that I do be a pleasure. I do have access to some just to me. Delighted to help facilitate.
Yeah, super. Any questions? Okay, super, thank you so much.
Thank you.
Appreciate your time. All right, super. So that's it for 138 today. Hoping to take some further testimony on that, hopefully have a new draft at some point here. So. Yeah,
Make sure you hear from the LCT, and
yes,
because I've
absolutely.
concerned about town's ability to do this and their sophistication and burden and how it would work on their end.
Well, and my hope is to have a new draft that accounts for some of what I would anticipate being their concerns. So, but yes, yeah,
Okay.
I would love to, because I think if it doesn't work for them, then should do it.
Yeah.
Yeah.
And we have just some towns that they have no paid staff, or they have like one half-time staff, and things like that. So,
Yeah, well, and especially if this has been adopted by 40 other states, we can't be the first to try to tackle that question, and so how are other states with very rural towns navigating this?
I'm sure, but we have some pretty small.
Yeah,
towns,
yes,
so.
fair. Okay, sounds great. So we're gonna switch topics, and we're just to put it on the radar for the rest of the day. Thank you so much. We're gonna hear from Martin Malecki. Did I say your name? Yay, great. From A&R, and it's a change from what might have been on the agenda this morning. I think we may be hearing from some dairy farmers a little bit later, so that's also on the radar. But for now, speaking to 224, remember this is a lakes related bill. Welcome, Laura.
Thank you. Thank you so much for having me. For the record, my name is Laura Tulecki, and I am the Lakes and Ponds Program Outreach and Policy Coordinator. And I work for the Agency of Natural Resources, Department of Environmental Conservation. So thank you for having me back today to speak on this topic. And I hope to briefly provide some feedback on some specific parts of S224, specifically on the components about municipal delegation and the addition of the home lake rule. Both of these fit under that use of public waters umbrella. So I'll start with municipal delegation first. And I had the opportunity to be here last Friday, and that was really helpful for me to hear the reading of the bill and some of the legislative council's input to kind of understand the context of this issue. And based on what I've heard, I don't think that this proposal for this municipal delegation issue will help achieve the goal. And kind of just to frame the issue a little bit, if a town wanted to request municipal delegation for the use of public water tools, they would then they would do that through a petition process, and they would then have to administer the use of public waters rules as written. And they would have to conduct enforcement on their own, and they'd have to have a good amount of capacity to be able to do that. And according to the existing use of public waters rules, a municipality is basically required to implement the use of public waters rules as written. So municipal delegation isn't a chance to kind of make up a bunch of, not make up, but create several rules that are inconsistent with what's already there. It's not kind of a blank slate. However, as another opportunity to address lake-specific issues, if a town has some sort of unique scenario that would require an exception to how the use of public waters rules are administered, they could petition the state for a lake-specific rule and demonstrate why it's required because there is this unique scenario at that lake. So these are two different approaches. It means the municipal delegation or lake-specific rule. And I don't think that delegation is necessarily always the right approach because, again, you have to be consistent with the existing rules. And you have to have a certain amount of capacity to administer those rules. And we don't have any examples of towns having full delegation of the use of public waters rules. We've had since the beginning of the use of public waters, we've had 3 towns have what we've called partial delegation. These were Shelburne, Colchester, and Newport, and it's very specific. They have town operated mooring zones that they manage, but no other components. So that's the only scenario that we have. We've never had a town take on the full administration of these set of rules. And the type of scenario that was described in S 2224 about the drinking water reservoir, I think that it would be more appropriate to have a lake-specific role to achieve some sort of goal about what types of watercraft are left on a specific water body. And I want to clarify also, or just explain that the use of public waters rules can be used to regulate a type of watercraft, size of watercraft, speed of watercraft, where on a water body the watercraft can operate or times of day, but it can't dictate access to the water or regulate fishing activities. So from the, I'm sorry,
What can't dictate?
the use of public waters rules are specific about what it can be used to regulate. So it cannot make rules about access areas or how the lake is accessed or whether or not fishing is there. And from my understanding, municipalities also do not have the authority to regulate whether fishing happens or not on a specific water body. So at the description provided last Friday about the issue at Thurman W. Dix Reservoir, it to me, it sounded like a coordination issue between the requester of the fishing derby and the municipality and Fish and Wildlife, the permitter. And I don't think that, when these issues were about land access and I think kind of just notification and communication, and I don't think that having municipal delegation would necessarily address that issue. And in looking at the existing use of public waters rules now for Thurman W. Dix Reservoir, they already have a lake-specific rule saying that there are no combustion motors allowed on the lake. So just small fish trolling motors are allowed, but no combustion motors. And they have a prohibition of traveling about 5 miles per hour on the lake already. So there are some existing protections, but there could, additional ones could be explored. And then in general, on the subject of municipal delegation and use of public waters rules, as you're likely aware, we're currently in formal rulemaking. We have already been through ICAR in December, and we're in our public comment phase right now. And we put forth a lot of proposed amendments to these public waters rules, but one is specifically focused on municipal delegation. And in the existing rules and within the statute, the language is quite vague. And so we have proposed language about the roles and responsibilities, the process, how compliance will occur. We've really kind of added a lot of detail to what municipal delegation entails and when it's appropriate and how it should be administered. So because we're putting out these proposed rules specifically about municipal delegation to have a better handle on how it works, and also the provisions for examples of partial delegations, like the mooring zones, how that's best handled. We don't support that, this provision about municipal delegation.
That is helpful. What I am also hearing is that there is through the use of waters rules, there's actually no way that you can prevent people from being on the water.
Right. The town could decide if, that they could say no trespassing. I don't know, town ruled exactly if they can actually say that, but because it's private property owned by the town, they could say no trespassing or something, but we have no control over that in the use of public water sources. Yeah, that's not popular. It's really a conflict resolution tool for managing watercraft.
Okay. Interesting. Yes.
Since you are proposing new rules, could you send those draft rules to us so we can see them? Because as our attorney likes to remind us, we can go through all the rules.
Right.
We don't like what you're doing.
Sure.
Not to say we would,
Right,
but also I think we should get clear on what municipalities already can do, because I think, at least in town forests, I believe they can say if it's town forest, they can regulate hunting at a town forest. So I wonder, can they regulate fishing on a town pond or lake? But I don't know the answer to that, so it might be helpful to get clarity on that.
Water trees are property in the state.
Pardon me?
Waters are the jurisdiction of the state.
Yes.
Oh, so yeah, more than land,
Oh, yeah, I think it was a big difference.
because of Clean Water Act probably, but
Yeah, I don't know where I remember this, but I think that's how they look at it.
got it.
And it might be a good question for our colleagues in Fish and Wildlife, just like I have been told that municipalities do not have the authority to regulate fishing on public waters.
Oh, interesting, because, and I might be wrong about the hunting thing, but I just know that there are towns, there's been
Right.
big discussions in
Right,
South
where-
Wales, that town,
yeah.
where they
Oh, yeah.
hunt,
Yeah.
they can hunt.
You can use rifle within the.
Right.
Exactly, yeah, all those things, yeah.
Yeah, on the way into Montpelier is like, no,
Exactly, yeah.
no, what
Yeah.
hunting,
The
buckshot.
rifle, yeah.
Yeah.
You know.
Yeah, for the signs.
Follow-up question,
Yes.
about all of this, which is low down my grade. So in terms of the use of waters, there's no, as I understand it, there's no special treatment or possibility of, a different set of standards for, say, a town's drinking water.
It's not something that's currently in the standards. I think that there is language that, if there are these unique scenarios that require different levels of protection, I think it's something that we can contemplate. But it's not, there is no language about specifically that scenario.
For drinking water. And I mean, can you imagine what those circumstances might be that would require, or that would be conditions for, well, this is a town's drinking water source, and so therefore it should, or is drinking water as a condition not sufficient for a higher level of protection?
So I don't have an exact answer for that, but I can imagine that it would be a scenario that we can take very seriously, and there are drinking water and source protection regulations in play. So perhaps, you know, if there were specific threat that we were aware of, or something that could move us back and go forward a little more, but I don't want to speak too much on that, just because it's not something that currently exists. But I could see that being a compelling issue to address.
Any other thoughts?
No, but something.
Yeah, okay. Thank you. This is learning every day. So,
Yeah.
and good to know, sort of the policy lay of the land, for.
Yeah.
And my understanding, I don't know if you're aware of any of this, but my understanding is that other states have some higher levels of protection for their drinking water.
Yeah.
Can you speak to any of that? If you don't know, that's okay.
No.
Because I'm putting you on the spot here.
Yeah, a lot of the drinking water reservoirs are like under the jurisdiction of the drinking water program, and they may have certain standards that they're adhering to, but I remember on Friday, you were talking about in other places where certain reservoirs have been fenced off. I've not seen that in Vermont. A lot, I think that like Rutland City Reservoir is private, and I think that they have it pretty. I'm not sure it's like fenced off, but I don't think people can recreate it.
So, well, okay, so this is getting at the question, because you said if the water is public, then there was a certain set of standards that would apply, but how then can there be a private? Is it owned by an individual, like a person, and that's what makes the water private? I would think that
Yeah.
all water is.
There is some language about, so surface waters are waters of the state, regardless. But as far as what's jurisdictional, the use of public waters rules, it depends on if the water body is public or private. And there's a specific definition in the use of public waters about what a private pond is. And so it's basically smaller, has complete ownership. And so the use of public waters will still apply to these private water bodies.
That's fascinating. So there's some kind of a distinction because of the size. And if it's a public entity, like a municipality that owns the perimeter. I'm gonna have Sir Williams hands first, we'll go with Sir Williams.
Rutland Reservoir is a man-made on city property. It was constructed by the Army Corps of Engineers. So it may be.
It's also, yes, it's also artificial because of that. It's also private. It has to do with size, whether it's natural or artificial, it's all on one property. These are the kind of components that we look at, because private pond definition. And so then in those cases, the use of public waters rules do not apply.
Okay, yes,
So it may be a private pond, but it's still a public drinking water system. So it's regulated in another division of DEC first with water systems, because it's supplying water to a lot of people.
I don't know that, because we just had a tour of it.
oh my gosh, field trip.
They're actually harvesting.
Follow cybersecurity rules when we're there, and then let you take video and all that.
Okay. All right, me thinking about this a little further, so
Okay.
thank you.
Yeah, you're
Appreciate,
welcome.
your testimony this morning, that's very helpful. So I mean, yes, go ahead.
Oh, well, I did want to also talk about the home lane rule.
Oh, I'm sorry.
Yes.
Here I was thinking that we were done, but we're not done. Okay, thanks very much.
Okay, so switching gears, I wanted to talk about the home lane rule. And first, I want to acknowledge that this is probably an issue that you've heard about. We've certainly heard about quite a bit of agency, there's a lot of interest, concern regarding this issue. Just to refresh your memories, basically, what the home lane rule is that for wake boats, that they should have a sticker that identifies their home lake. And then they can return to their home lake without decontaminating, but if they go to a different lake, that's not their home lake, they have to decontaminate. And this is because wake boats have these very large ballast tanks that are difficult to drain completely. And so there's an increased threat of the spread of aquatic invasive species by the ballast. So that's why this was, why this has been put forward. And I just want to say that spread prevention is a really, really important part of our work in the Lakes and Ponds program, and also with our wake sports rulemaking efforts. And we're committed to improving spread prevention efforts, but we do not believe that the home lake rule is the way to go. And we are engaged in formal rulemaking now, as I mentioned, and our proposed amendments include the removal of the home lake sticker program and the proof of decontamination requirement, and replacing those items with requirements specifically for wake boats to decontaminate in a specific way, and clarifications and requirements regarding decontamination requirements for all watercraft. And the decision for this change is based on our operational and administrative experience during the last couple of years of this rule being in place, and our evaluation of how effective this sticker program is. And I want to say it was really well-meaning. The sticker program was originally proposed by our agency, by my predecessor, and but it's not implementable as written. And I'll just kind of explain the details of why we've come to this conclusion. So within the state of Vermont, there's no system to register and track wake boats. We also know that boats are coming from Massachusetts, New York, Canada, further afield. We can't get some sort of alert system when wake boats come into the state. When motorboats go to the Department of Motor Vehicles to register, there's not a question, is this a wake boat or not? We have had conversations with the DEP. Could we include this? Is this something that you'd be interested or, supportive of? And it's kind of we've hit a brick wall with that. We're not really able to track the wake boats within the state. So we don't have a comprehensive list of wake boats. We have anecdotal information, but we don't have a list of wake boats. And we know that they're coming from other places. So we don't really have a way to intercept these boats and get them a home lake sticker. Obviously, we could print stickers with individual lake names on it. That's not a barrier. We could do that task, but it's the distributing them that becomes the barrier. And if a boat were to come on a mid-afternoon Saturday and hey, I got my full decontamination, I'd like to go on this lake, but they can't because they can't get a sticker. We don't have the staff to have that kind of quick response to administer a sticker on the spot. And also the presence of a sticker doesn't necessarily guarantee that a boat has been honest, that they haven't been somewhere else. So all of these kind of issues have come up and kind of led us to think the sticker is not really the way to go. When the existing wake sports rules were adopted in 2024, we were really optimistic about this provision. We were excited about it, but it really became clear that it was very difficult to implement, and administratively, it was just a task we couldn't really rise to meet. So we had to really quickly change gears immediately as this rule went into place. And we really wanted to focus on the intent, maintaining the intent of this rule, which is spread prevention. And so what we did was require when wake boats travel between lakes that they receive a decontamination. And this is the exact same thing the rule requires now, just without the sticker. Because it's a little bit of an unachievable goal. And we don't feel like it really added that much benefit. And one benefit though of having this is this issue of watercraft decontamination has really risen in prominence more broadly across the state and for all boats. And I mentioned this on Friday, but wake boats are a really, really small percent of boats in Vermont. About 1% of all motorized boat launches observed at public access reader area program stations were wake boats. So and then even fewer of those boats are actually traveling between lakes. So in 2024, we counted 22 boats traveling between lakes. In 2025, we counted 17 boats traveling between lakes. Obviously, there could have been a couple more, but this is a representative sample, talking about, a few dozen at the most. And we feel like we can target those boats for more detailed decontamination. And in our proposed rules that we're putting forward, we're actually proposing language that lake boats traveling between lakes receive a hot water decontamination to address the threat of zebra mussel veligers. And so we want this to be, our proposed rules going forward to be more protective. But then we also have provisions in the rule that focus on decontamination for all watercraft. So obviously, a wake boat, ballast tank may pose a higher threat than another type of boat. However, we're talking about 20,000 boats moving around versus 22. And so we really need to focus on that larger amounts of boats. And, we take threat prevention for wake boats and all other boats very seriously, but focusing our limited decontamination resources on just one type of watercraft isn't really the most effective use of our limited resources. And I guess I just want to say that our proposal to have this hot water decontamination requirement will impact, a relatively small number of boats. So all of that is to say, we don't support the home lake sticker program, and we've been working really hard on an alternate solution because of the implementation problems. And I think one of the really hard things, communication wise, is the public was very excited about this, as we were. We thought this was going to be great. And so us proposing that we want to remove this home lake sticker, it's been perceived as a removal of protections. And I think that's a communication issue on our part. We're working on having some more discussion, especially in this rulemaking session, to really clarify that this is not a removal of protection. It's a different way to achieve the same goal, and we actually hope to be more detailed in what the decontamination requirements are than this home lake provision. And we have to get really creative because we don't have a statewide network of high capacity decontamination stations. We have some along Lake Champlain. We have a department mobile unit. We've worked with some boat operators, marina operators who have offered to do hot water decontaminations for lake boats. We're piecing things together, but we don't have the capacity to have these statewide approved decon stations as we originally hoped. But that is a goal we're working towards. We've put a lot of effort in. The program manager, Jenny Austin, this year, and she's been heading up some stakeholder groups, developing alternative scenarios for improved decontamination across the state. This is a high priority for our program. So there's a lot more infrastructure to be built out in this area, but we are working on it. And operating these take training, skills, experience, funding. So we're looking into all of this. And I think that includes the comments on all of them.
Okay, great. I have questions, but there's questions too. We'll go to Snre party, that's Snre.
Thank you. That's a helpful explanation for an issue that's gotten confusing for me.
Yeah.
But one, also could you send us that proposed rule?
Yes.
Maybe we already have it, but it would be helpful to have both of these rules maybe are the two really help us understand them. Then you mentioned the DMV. And so if you're lucky enough to have a boat in Vermont that has a motor, you have to get a license, right? You have to register with the DMV. And is there a fee?
I'm sure there is.
Okay.
I don't know what it is.
And does that fee go to DMV or do you all get the?
No. This is the fee. Okay. And some of it goes, the motorboat registration. Sorry, for the record, I'm Jenny Austin, Lakes and Ponds Program Manager.
The fee that people pay at the DMV, part of it goes to DMV and part of it goes to other agencies. It's currently a issue right now because the Coast Guard wants us to split that fee out, and that's another issue that we're dealing with.
Coast Guard does?
Yeah,
Why do they get to decide?
well, it's their fee, it's a federal fee that regulates watercraft all over the United States, I guess. And so we receive funds currently, our department, as well as Fish and Wildlife. And then there's some other, I think, Agency of Agriculture that also receives some of the fee for mosquito control and that sort of thing.
Wow, so like you all get pennies probably, cause I can imagine.
There's a percent that we get.
Yeah. Okay, and is there any interest in, when we were talking about where these decon stations should be located, and I was like, oh, this doesn't seem like it's that hard of a problem to solve. I mean, the money is the harder problem, like what, how do you pay for them?
I think we could certainly prioritize, we know which lakes have what type of invasive species, we know which ones are threats, we know which ones people are visiting a lot.
Right, and where you could.
We could prioritize, here's a spread vector, okay?
Exactly.
We would love to have a hot water decon station here.
Have you, I mean, it sounds like you have talked to some private boat launch or boat
Boat dealers.
boat guys, boat people. Do any of them, I mean, cause I would assume that there's a fee that you could charge to decontaminate somebody's boat.
I think that could be a potential, we have talked about it, could be a potential business opportunity for
Yeah,
these folks. As far as I know right now, that's not something that they've been, I think they've just been doing it as courtesy.
That's good too, if you don't do it for free, but, okay. All right.
It's interesting, just kids.
I've been given this a lot of thought, there are some solutions to this, it's called RF tagging. Trucking companies do it, they can actually use a satellite to monitor where the vehicles are at all times, how fast they're going. You think about OnStar, General Motors had for vehicles, that's a possibility that someone in the state of Vermont would know every time one of those was moved. Because you can't enforce it if you don't know where they are. Number two is that you could have a mobile decontamination device and have people that are gonna move it from one lake to the other required to contact that decon unit, a couple days before they're gonna move it and actually schedule that in there. But I think that, we don't know how many wake boats there are in the state, because they don't register them. So we may be talking 22 boats, we may be talking 2200s, but it would have to be, you wouldn't maybe be able to catch up with all those boats that are registered until the next time they register. And maybe it could be an interstate agreement where somebody from New Hampshire and Massachusetts brings the boat in because they're legally registered in that state. That you could do something like an interstate compact. Just some thoughts.
Or you mentioned that you've got a couple dozen wake boats change water bodies during the year. What's the number for just all the other ones? Do you have any idea of those?
Yes, I don't have the exact number, but I'm guessing it's probably 10,000-12,000 range.
In a 5-month season, so a couple thousand a month, yeah.
Every inboard and outboard motor uses lake water to cool.
Sure, of course.
Are you thinking about doing a boat cleaning business? You could attack the or.
No, I mean, just try to figure out the scale of the potential.
Yeah.
But I mean, yeah, you're right, if you're running an outboard, you're running it through this cooling, you've got whatever attaches itself to the hull, whatever might end up in the bilge. I mean, there's a lot of places to go.
So we don't need to, okay. Sorry. I have a follow-up question. So one of the things that we heard, I guess I just want to say this out loud and recognizing that if you don't want to comment, that is perfectly fine. I just want to recognize that part of the bill is putting these decon stations, allowing them to basically be on the priority list to
Yes.
take up a space. And recognizing that there may be a conflict there, right? Like, so when I hear you describe, we know what lakes are contaminated, we know where there's a lot of movement between lakes, we know, so effectively like what lakes are at risk. It makes me wonder about, specifically, having decon stations at these high risk locations, or that there's there could be a strategy to where these decontamination stations ought to be.
Yeah.
And that they should have some level of priority for being there, especially when it's busy. So just thinking about how that fits, how decontamination fits into the use of the land. And I don't, again, so if you don't want to comment, totally understand. If you have comments, would welcome that, but
Yeah, I don't necessarily have a comment,
that's fine, no worries. I just want to recognize
yeah,
that as, you know, this is a value that we hold, we want to keep our lakes high quality.
as the lakes program, we want more decontamination available widely.
Yes.
So, under we talked about changing the system from able to, in a way more decontamination. How does that get enforced? How do you know whether code has followed the rules before it ends up in the next lake?
Yeah, you know, it's basically an intervening process that's done by a public access reader.
If they go into a place where the.
Correct.
Yeah, okay.
Yeah, again, we have, with our use of public waters rules, with most environmental regulations, we have very limited enforcement coverage across the state. So we have to rely very heavily on outreach and education. And we do have partners within the wake sports community that we can work with to disseminate this information and get it out. And I do, you know, I believe that most people are good actors. We can do our best to get the information out there, and then the readers can inform people and educate people as they're entering the water body. There is enforcement of the game ordinance, but it is, you know, we have to acknowledge that it is not ubiquitous at all times. So it's a big lift of education and outreach about this topic.
It also seems to me that if this rule moves forward, that all boats need to decontaminate if they are coming into a new body of water, or, sorry, go ahead, you were gonna say something.
Well, it's not necessarily that all boats are required to decontaminate the water bodies. It's they're required to follow decontamination requirements if they meet a certain criteria, all the other ones.
Sure.
Yes.
Sure, so just to play that out, it seems to me that the opportunity to decontaminate needs to be available. And believing that people, you know, our boat users are good, want to be good actors, and so they want that opportunity. Seems to me that decontamination should be an option. Anyway, just putting that out there. Yes.
Do we know what does it cost to have a decontamination station? So, like the hot water, for instance.
Yeah, the larger capacity.
Yeah, there are different sizes and capacities for these units. The largest, highest capacity ones are about 150 grand, I think, for each one, and that includes staffing, technical with training, and the actual cost of the unit. These are
How much of that is the actual cost of the unit of that 100?
I can send you guys all of these numbers. We have a report that we are in the final stages of finalizing, and it's a year's worth of efforts by my program as well as a stakeholder group to come up with, analyze all of our watercraft inspection decontamination programs, determine strengths and weaknesses, figure out where the gaps are, and identify some action items, a menu of improvements. So you mentioned seal and receipt type of a program where we have the ability to track when somebody's had a decontamination and they're coming into a lake. That's like one idea of many that we've compiled, and we've actually costed out the cost for each of these little improvements, menu of improvements, and then we've developed a stage plan for a 10-year plan for trying to get to a better level of protection that we think we need to be. Of course, that would include additional funding and resources and staff to achieve that level that we think we need to be, where the stakeholders think we need to be. But yeah, that's what this report will hopefully provide, and it includes the costs of with the actual unit costs, but in very detailed tables of all the different.
So that's it.
Sure.
Yeah.
Yes, good.
So we talked a little bit about that last week, I think, that, any boat that's registered anywhere in the country can come to the state. So what federal regulations are gonna be involved in this? So that's something we're crossing the line there too, or we're gonna have to look at federal, just interstate commerce.
I don't believe so,
Okay.
because, boats travel across borders all the time, and then they're subject to different state regulations that may require decontamination, and I don't believe there's any, federal conflict there.
Okay, thank you.
You're welcome.
Very much appreciate it. Any other questions at this point? Okay,
Just a logistical, if I want to send everyone some information, shall I send it to?
yes.
Okay.
Okay, great. Okay, thank you so much.
Thank you.
Appreciate it.
Bye.
Same. Okay, so I did also just hear that we are not in fact going to be hearing from the Fair Farms unfortunately today. So with that, we are done for the day, so we